Hello friends, welcome. In this class, I'll be discussing about the Wildlife Protection Act 1972. So before moving into the details of this act, let us try to understand a little bit of history of this act. So the history started way back in 1960s when Srimati Indira Gandhi ji was our Prime Minister, the then Prime Minister. We all know Indira Gandhi as an iron lady, so known for first nuclear test, national emergency and all. Very few people know that she was a very big environmentalist and also a wildlife expert. So she was very much concerned about wildlife. It was during her time that this act was enacted, and it was during her time the Project Tiger was started. Okay, so in 1960s, there was news that the wildlife in India is in a very bad shape. Okay, so that was in 1960s, and there was some news which was spreading around that the wildlife in India is in a very bad shape. The government got notice of this, and the then Prime Minister arranged a task force to verify this news, whether it is true or not. So under Dr. Karan Singh, a team was made and it studied the wildlife situation in India, and it confirmed that the wildlife is in fact was in a very bad shape in India. So because of that, the government had to take some action, and as a result of it, as a result of the report which was submitted by the task force headed by Dr. Karan Singh, the first wildlife related act of India called as the Wildlife Protection Act 1972 was enacted in the parliament. So that was a history. So it was enacted mainly because of the situation of wildlife in India, which was very bad in that period. So let us move ahead and see the details. Wildlife Protection Act obviously will be having certain objectives which are related to the wildlife. The first objective is for the protection of wildlife. When you say wildlife, it not only includes the wild animals, it also includes the wild birds and plants. So when you define the word wild, it is basically anything which is not domesticated. Anything which is not domesticated is called as wild. So it protects the wildlife, including animals, birds, and plants, and it empowers the central government to declare particular areas as sanctuaries and the national parks. So usually we have 4 areas which are mainly dedicated for the wildlife conservation in India: wildlife sanctuaries, national parks, conservation reserves, and community reserves. So regarding this in detail, I'll be talking about later. So initially, we'll just see the objectives. The central government is empowered to declare any area as sanctuaries, national parks, for the benefit of the wildlife, for improving the wildlife, for conserving the wildlife, and for protection of wildlife. It prohibits hunting of animals. So hunting is not just killing. Hunting includes various things like trapping, capturing, possessing the prohibited animals, the sale of prohibited animals. All of these comes under hunting. So it prohibits the hunting of animals, and if anyone infringes that, then it also has provisions for punishment. Very few acts will have provision of punishments. Usually the crimes in India are dealt under a specialized section in judiciary, but there are few acts which imposes punishment under the act. So this act has been empowered to impose punishment of the wildlife crimes. So overall it has 7 chapters, and out of this the most important chapter are chapter 3 and 4, which we will be dealing in detail. It has 66 sections and we'll be dealing about all the sections, and it had 6 schedules, but now it has been reduced to 4 in the amendment. So recently it was amended in 2022, and in order to understand that amendment, we should know the original form of the act, so that we will know that what amendment was being made and what changes has been made, so that we can compare that how it was earlier and what are the new things which has been made. So it allows the government to form the Wildlife Advisory Board at both the national level, called as National Wildlife Board, okay, National Board of Wildlife, NBWL, and every state has a State Board of Wildlife. So these are the Wildlife Advisory Boards at both national and state level, which takes care of the wildlife related issues. Okay. Having said that, we'll see some of the salient features of this act. What are the different salient features? See, this act protects the wildlife, and not only the wildlife, the rare plants, okay, birds and other organisms, okay, which are in wild. It allows the government to establish PAN, which means the Protected Area Network. Okay, so in India we have a very well defined network of protected areas for conservation of wildlife. So it allows the government to establish the protected area networks, and zoological parks are called as zoos for protection of wildlife. And in this act, as I said, hunting is not just killing, it also means capturing, trapping, poisoning, injuring, destroying, or taking away any part of the body. All these activities comes under the category of hunting under this act. So, as I said earlier, before the amendment of 2022, there were 6 schedules. So these 6 schedules now have been reduced to 4, but let us see how it was earlier. So earlier the 6 schedules were like this. So schedule 1 contained the mammals, amphibians and birds in 3 subheadings. So all the important mammals like tiger, lion, wolf, cheetah, chinkara, dugong, elephant, rhino, buffalo, and all these mammals came under this schedule 1. Anybody who hunts any animal which is listed in schedule 1 would attract same punishment. So you kill a tiger, or you hunt a tiger, or you hunt a musk deer, the punishment will be the same, and it will be really severe. You will attract a severe punishment for killing any animal which will be listed under schedule 1. Then schedule 2 has part 1, part 2. So it has in part 1 Assamese macaque, Bengal porcupine, chameleon, wild dog, okay, langurs and others. And in part 2 you have fox, polecat, Indian cobra, king cobra and others. Okay. So this is section 2 of the second section of the act, so which has little lesser punishment than what what people get by hunting the animals in Schedule 1. Then we have Schedule 3 containing cheetal, hyena, sambar, gorals, and Schedule 4 hares, falcons, kingfisher, dove, owls. So they comparatively has lesser punishment and lesser imprisonment, lesser penalty if you kill any animal which is listed in Schedule 3 and 4. And now there is a special schedule which is now not there since 2022 December, but there was a schedule called as Schedule 5, and the animals which are listed in this was called as vermins. That means the animals listed in this did not attract any punishment if anybody kills it. So they had common crow, rat, mice, and fruit bat. So this was a list. If you kill a rat, a bat, or common crow, so you will not be attracting any punishment or any penalty under this act. So they are called as vermins. So there is a chapter which we'll be discussing where the Chief Wildlife Warden, upon the request of the state and the Chief Wildlife Warden, the central government will declare certain animals which are listed here as vermins and will be placed here. So during that period of time and during that particular area, that animals were considered as vermins, and if anybody kills that, they would not be attracting any punishments. So I'll be discussing that at the last, but there are provisions that the Schedule 5 could be updated earlier. Now the last schedule, Schedule 6, contain certain plants. The plants whose possession, sale, plucking, and taking away will be completely prohibited under this act. It contains bedong cycad, blue vanda, red vanda, kuth, pitcher plant, okay, red slipper orchid. Okay. So all these are very rare plants which are protected under this act. Okay. So that is the schedules, and this is the table of schedules. Now let us see some of the chapters. Okay. As I said, there are 7 chapters under this act. Chapter 1 talks about, as in any other act, it talks about the general definition of terms. What is the meaning of the terms? So what are the different terminologies? So the boundaries of certain areas and others. It's a very general definition of the act, explaining what this act is and what are the different terms means and others. Okay. That is, chapter 1 is not important for us from the examination point of view. Then chapter 2 talks about the authorities to be appointed under the act. The conservation of wildlife requires many authorities to be appointed. Say for example, Chief Wildlife Warden, then the directors or chairmen of both National Board of Wildlife or State Board of Wildlife. Okay. Then the heads of the zoos. Okay. So there are so many authorities who will be appointed under this act. This act provides the provision for appointment of many official authorities, government authorities for protection of wildlife, and that authorities will be given in chapter 2. Again, from the examination point of view, it is not important. So it is not just the authorities, but even some of the organizations like Wildlife Crime Control Bureau, then National Tiger Conservation Authority, and all these organizations which comes under the wildlife protection is given in chapter 2. Chapter 3 is very, very important. So chapter 3 was included in one of the amendments which we will see, but this became a very important chapter, so for protection of wildlife, and we have to know about this in detail. So chapter 3 talks about the hunting of animals and destruction of plants. So anyone who hunts the animals which are given, or he destroys the plant or takes away the plant which are listed in the schedules, so they are punished under chapter 3 of this act. What is this chapter 3 talks about? In chapter 3 there is a section called as section 9. Section 9 prohibits the hunting of animals which are listed in schedule 1 to 4, except for 5 which comes under vermins. So whatever the animals which are listed in schedule 1 to 4 are prohibited from hunting under section 9, and there is an exception. So the exception is section 11 and section 12. So except under a special condition of section 11 and section 12, so these section 9 prohibits overall hunting of animals listed in 1 to 6. So what is this section 12? Section 12 talks about a situation where the chief wildlife warden of that particular area can grant permit to hunt any animals for various legitimate purposes, like for population control, population increment, or for translocation purpose, for educational purpose, for scientific purpose, or for any kind of captive breeding purpose, and for all those purposes. So if we just look into the reasons for which the chief wildlife warden can give permission for hunting the animals listed in schedule 1 to 4, okay, are for captive breeding, for translocation, for educational and training, for scientific reasons, for to extent tourism, okay, for capturing and relocating, okay. For all these purposes, the chief wildlife warden can permit. If anybody has a permission from the chief wildlife warden, then they can capture an animal or transport an animal from that place. Otherwise, it's not possible. That's an exception under section 9. So first exception is section 12. Okay. Then there is one more section which is an exemption to section 9. So section 11 of chapter 3 Wildlife Protection Act 1972 says that the chief wildlife warden can order the hunting of animals listed in schedule 1, only schedule 1, under 4 conditions. Okay. So there are 4 conditions to be fulfilled if at all anyone wants to hunt an animal which is listed in schedule 1. What are those 4 conditions? So first condition is it is a threat to human life. If at all an animal is posing any threat to human life, say for example, few years back there was a situation wherein in a Delhi zoo, a person just crossed over the boundary and he entered the place where tiger was enclosed. So tiger came to him, it was standing near him, so it watched him for a few time and then it took him by his neck, and because of the teeth injury, so injury by the teeth of the tiger, he died, so he passed away. A lot of people were standing around and they were throwing stones. This was a big news. So at that time, there was many debates like whether the tiger would have been killed or not. The answer is yes, definitely you can kill it. So it's not necessary to go to the CWW and obtain the permission. You should kill it and then prove that it was killed under a good faith. Okay, so to protect a human being. If there is any danger for human life, any animal listed in Schedule 1, including tiger, elephant, lion, any animal can be killed. So, okay, because human life is most valued, and if there is a threat to human life, then it can be killed. So second, if the animal is deceased. So any animal listed in Schedule 1 is deceased, and there is a danger of that disease spreading to other animals. So in order to prevent major loss, so you can kill the animal so that to prevent the spread. And third, if the animal is disabled and it is beyond recovery. So it is in a situation where it cannot be recovered, it is beyond recovery, it is in pain, and you are sure that it cannot be treated or recovered back. In that case, as a part of like what we do in humans, mercy killing, so we will be killing that animal listed in Schedule 1. So that is the thing. And the fourth situation, the animal cannot be captured, okay, or translocated, then can be killed. So very recently, there was a situation where a tiger had become a manhunter and it was troubling a lot. So people tried to capture it and relocate it, but it was not possible to capture. So then CWW ordered killing of this tiger. It was in Tamil Nadu. So immediately some people filed a PIL in the Madras High Court, and the High Court ordered the Forest Department again not to kill the animal, the tiger, but to capture it. Okay. So that happened, it went for a very long time where they were keep on searching for the tiger. So these are the situations under which any animal scheduled in Section 1 can be killed or hunted. Then under the same section, there is a provision that the Chief Wildlife Warden can order the hunting of animals listed in Schedule 2, 3 and 4 if that animals is causing damage to the property. Okay, even if it is causing a damage to the property, then it can be killed. But if the Schedule 1 animal is causing damage to the property, then it cannot be killed under, it has to be those 4 situations. But these animals, even if they are causing damage to the property of human beings, then they can be ordered to kill by CWW. See, killing an animal in good faith is not a crime. So if you prove that you have killed it because of any of these legitimate situations, then you will not be punished. But the body of the killed animal will belong to the government. You cannot take away the body. So that's the thing. There is one section under this chapter called as Section 17. It protects specific plants which are listed in Schedule 6. Okay. So the sale, purchase, possession, plucking and transaction of any kind with these plants will be prohibited. It is prohibited under the Schedule Section 7 of this Act. So that is about these 3 chapters. The next chapter talks about the PAN, or simply called as the Protected Area Network. So under this chapter, it talks about how to protect a wild animal or wild life. So by these areas, okay. So initially it was only 2. Now there are around 4 protected areas dedicated for the protection of wildlife. So India has a very, very solid and concrete system of the in situ conservation method. Okay. So the in situ conservation of the wild animals is done by a very properly structured dynamic system called as protected area networks. So different category of these networks, different category of these protected areas have different objectives, okay, depending on the importance and why it was established. So it established 4 types of protected areas. One is the sanctuaries, or simply wildlife sanctuaries, okay, national parks, conservation reserves and community reserves. So till 2002, it was only sanctuaries and national parks. So say for example, we had these kind of sanctuaries, okay. Okay, and then we had some national parks here, national parks, okay. So these are the areas which are enclosed and in situ conservation was practiced. But what was happening is that we know that there is a boundary. This is a national park boundary and the human should not go inside without permission, or any kind of protection is there. That is known to the humans, but animals don't know it. So for them, the entire forest, even though a very big stretch of forest is divided into 2-3 protected areas, they don't have this boundary concern. So usually what happens, animal has this habit of migration. Usually, say for example, elephant. So they'll be near the food source, usually during the rainy seasons, and in summer season they will go near the water source, and they keep moving to and fro in a particular path, so in search of food and water. Okay, for various purposes, migration is done for breeding, for food, for many other weather conditions. So they keep on moving from one place to another. So say this is the path where a wildlife moves. So which is called generally as the wildlife corridor. Okay. So basically the developmental activities inside these protected areas were prohibited, but people could have done the activities outside these protected areas, and because of these activities which are done outside these areas, there were lot of disturbances, lot of impact of these development activities, both in terms of corridor or even for the ecology inside. So what happened in 2002? They started joining these protected areas with one another, and we established not just protected areas but a network of protected areas, so which is called as protected area network. Okay. So this is the present situation. So we have a very well established network, and these areas which are joining two protected areas were called as either conservation reserves, if at all this land belonged to the government and the management, the land use is controlled by the government, then it was called as the conservation reserves. Or if this land is owned by a community, it's called as community reserves. Okay, community reserves, and usually the ownership remained the same. The community or panchayat or any of the village, they used to have the ownership, but there was just a slight change in the land use pattern. Okay, so to favor the wildlife. So this is what is 4 types of protected areas. So we'll have a very better look at these things. Wildlife sanctuaries. See, wildlife sanctuaries being one of the protected area, has certain characteristics. Okay. See, first of all, if an area is important from the ecological, zoological, environmental, faunal, floral, now all these situations, all this point of view, if an area is important and if the state feels that, so it is the state government who intend to declare this area as a wildlife sanctuary, then it can notify the government that we are going to declare this as a wildlife sanctuary. It is actually proposed by Wildlife Sanctuary and with the permission of the National Board of Wildlife. So the notification is also done by state government. So that means to say proposal and notification both are by state government. So if at all a wildlife sanctuary has to be denotified, the state government itself can do that. There is no involvement of national government or central government in that. Okay. So it has restricted human activities. Okay. So it allows some of the activities like to a certain extent tourism, so to a certain extent photography. So if there is any study, research, scientific purpose, so for all these reasons it is allowed. But general activity and very common activity of humans will be restricted. Okay, there is a limited restriction on human activity. So it is mainly species oriented. So generally it will be oriented or it will be mainly concerning a particular species. Say for example, so there is Vikramshila Wildlife Sanctuary. It is mainly concentrating on Gangetic dolphin. Okay, so there are so many sanctuaries which are, all the sanctuaries are mainly concentrated on a species, oriented to a species. Chief Wildlife Warden can grant permit, okay, to certain activities to be done inside, and there is no core and buffer principle as in national parks. So the zone will be divided into the central zone called as core zone, and outside there is buffer zone. So this is the model which is followed mainly in national parks, tiger sanctuaries. So in buffer zone limited activity is allowed, and in core completely all the activities are banned. So that kind of categorization is not there here. Okay, so the core buffer principle is not there. So one exciting and surprising thing is it can be privately owned. So anybody has a land and they grow a forest and it becomes important from the bird and animal life point of view, then it can be declared as wildlife sanctuary even though it is owned by private people. So there is one Sai sanctuary in Karnataka which is actually a private wildlife sanctuary. So there are 551 sanctuaries in India and these number keep on increasing. So it is not static, it is dynamic. So whenever you are writing the exam, just 1 or 2 months, 2 months before the exam, if you could update yourself with the numbers, that will be wonderful. If the wildlife sanctuaries becomes more important, so it can be upgraded, it can be declared to be a national park, it can be upgraded to a national park. Okay, so that is the thing. These are some of the highlights of wildlife sanctuary and what it is. Moving ahead with the national parks. So national parks are much more important than the wildlife sanctuaries. So it is proposed by the state government. Again, when the state government feels that a particular area is important from the faunal, floral, ecological, environmental, from the point of biodiversity. So from all these points, for the conservation of wildlife, so if that area is to be declared as a national park, then it is again proposed by the state government, and after proposal the notification will be done by the central government. Okay, so and finally it will be established by the state government. Proposal and establishment is from the state government, but the notification of these national parks is from the national government. That is the reason a national parks cannot be denotified by state governments. Okay, you should remember this, because as it is notified by central government, state government doesn't have any power to denotify it. There is no human interference in this. Okay, even if that human is entering for any normal purposes, so without the permission he cannot enter the thing. So there is no human common interference as it was in wildlife sanctuaries. It is hitched to a habitat. Instead of concentrating on one species, it is concentrating on improving the habitat. Okay, so the entire habitat. So the boundaries are circumscribed by the government. It is clearly defined, and the boundaries cannot be altered without the approval of National Board of Wildlife. Okay, so it is circumscribed by legislature, and National Board of Wildlife, okay, has to alter it. If there is any provision both for sanctuaries and national parks to be converted to any non-forestry purpose, then it has to take the permission from the Supreme Court. That important, these two areas are. So here no alteration of boundaries are there. It is organized into a core and buffer principle. As I said, there is a area will be having a core zone, which will be very, very important, and it's a completely no-go zone. So, and there is some buffer zone where with permission certain small activities can be performed. So just like wildlife sanctuaries can be upgraded to national parks, the national parks cannot be degraded to the wildlife sanctuaries. Okay, so they cannot be degraded to wildlife sanctuaries, and unlike wildlife sanctuaries, they cannot be owned by any private people. Okay, it cannot be privately owned. So these are the provisions for the national parks. Coming to the third and fourth category, community reserves and conservation reserves, I've already explained what are these. These are basically the connecting areas between two protected areas, sanctuaries or national parks. So these areas are declared by the government, and it becomes a conservation reserves if it is uninhabited and completely owned by the government. We declare it as conservation reserves, and if that area, connecting area, is owned by a community, okay, so it will be named as a community reserves. Okay, basically it can be used for subsistence per communities. Ownership remains the same, and basically how you use the land will change. So there are around 127 community reserves and 88 conservation reserves in India. So some of the examples, conservation reserves. So Tirupati Marathur in Tamil Nadu, Hornbill Conservation Reserves, Bir Biraban in Haryana, Sri Naina Devi, Ajaz, those are conservation reserves. So community reserves like Kokre Bellur in Karnataka, Kadalundi, Valikunu, Arvakre, Bonchu, Keshapurcham. So these are the community reserves. Okay. So that is about the chapter 4, which talks about protected area networks. There are 3 more chapters which are not so important from the examination point of view. So, but I will tell you what are those. Chapter 5 talks about the trade and commerce in wildlife, how the wildlife trade should be done for a live animal or an animal part which is to be traded, how it is be done. All the provisions are there in chapter 5. Chapter 6 talks about the prevention and detection of offense. If there is any wildlife offense, then how it can be prevented, how it can be detected, how it is punished and all. And chapter 7 talks about miscellaneous aspects. And in these miscellaneous aspects, there is a section called section 62, and this 62 is the one which talks about the vermins which I was talking about. So the vermins which are listed in schedule 5, so that list can be updated, and how it is updated is given in section 62. The central government can declare any animal which is listed in schedule 1 and 4 if at all there is a request from the state government that that animal is causing menace to various things. Say for example, in Himachal Pradesh, monkeys were causing too much of trouble. They were troubling the travelers, tourists, okay. So they were causing too much of problem. So Himachal Pradesh government requested the central government to declare monkeys as a vermin for certain period. So during that period, in that particular area, so monkeys were considered vermin and killing of those were not an offense. So after that time, they were put back in whatever the schedules they belong to. So Uttarakhand had requested for wild pig because wild pig was destroying all the farmers' crops and they were protected under Wildlife Protection Act. So it was also put under the Section 5. And in Bihar, Nilgai. So Nilgai was also destroying a lot of crops. Okay. So this is the thing. Now let us look into the amendments of Wildlife Protection Act 1972. So the Wildlife Protection Act 1972 has been amended many times since it was enacted for various purposes. Okay, so there are various changes which were made during this, but some of the important ones I'll be talking about the important amendments which were made in different years. So in one of the amendment which happened in 1991, so chapter 3 which talks about the hunting was added. Earlier there were no chapter 3 in the act about the hunting of animals before 1991, and the Central Zoo Authority was established during this amendment. Okay. There were the two major changes happened in the act during 1991. In 2002 amendment of this act, the National Board of Wildlife and the State Board of Wildlife were established. Okay. So NBWL and SBWL was established in 2002 during this year's amendment, and conservation reserves and community reserves became part of the protected areas. Okay, became part of the protected area network. In 2006, there was a very important authority which was established for the purpose of conservation of tiger, called as National Tiger Conservation Authority. National Tiger Conservation Authority. So it was mainly after a very major incidents which happened in 2002-3 called as Sariska shock. So Sariska shock is an incident where it was found out that the Sariska Tiger Reserve had no tigers. So that was called Sariska shock, and the second task force of wildlife was formed under the government, and it evaluated and it recommended that there is more measures to be taken to conserve the tiger. More tiger reserves were established, okay, and all those happened. Okay. In 2007, the Wildlife Crime Control Bureau Wildlife Crime Control Bureau was established, okay, in 2007, mainly to deal with the aspects related to the wildlife crime. So it was earlier called as Tiger and Other Endangered Animals Crime Control Bureau. In 2003, it was changed. The name was changed to Wildlife Crime Control Bureau, but the role remained the same. So it was established in 2007 amendment. In 2013, so the government banned the use of traps. Before 2013, traps were being sold everywhere, hardware shops, so for capturing of animals. So using of traps were completely banned in 2003, And in the same amendment, hunting rights were given to some of the tribes in Andaman and Nicobar, because those tribes were completely dependent on the hunting and gathering activities. That was their livelihood. So the government gave the hunting rights to the tribes in Andaman, and there was international trade regulation policies which were updated during this amendment. 2017, there was an amendment where it was proposed that the National Rhino Conservation Authority be formed. So just like National Tiger Conservation Authority, but it didn't got finalized. And recently it got amended in 2021. So the bill was submitted, or bill was introduced in Lok Sabha in December 2021, but it was cleared in December 2022. So we consider this as the latest one. Okay, so we'll see some of the changes which happened in 2021. Okay, so let us talk about the Wildlife Protection Act Amendment Bill 2021. It was introduced in Lok Sabha in the month of December 2021, and it was passed in December 2022. Okay, so it is in force since 2023. It amends the Wildlife Protection Act 1972, and it seeks to increase the species protected under the law and implement the CITES. Okay, so there is a international agreement for trade of endangered species. Okay, so which is called as CITES, and this CITES will take care of the wildlife trade which is happening internationally. So it has its own list of animals called as appendices, appendices 1, appendices 2, and appendices 3. So, and they have listed some of the animals in those appendices. So in first appendices, it is completely prohibited from trading. In appendices 2, it has some animals which can be traded, but that should not be to an extent that it should endanger the animal, threaten the animal. And appendices 3 contains the list of animals which were requested by any one of the member countries to protect it. Okay, and it has to be respected by all other countries. So that is the provisions to implement the CITES, because India is a member of CITES. So to implement that, this amendment was mainly made. What are the changes? Okay, so because we know what was there earlier, it is easy to understand the change. We know that before this amendment there were 6 schedules. Now the schedules, number of schedules were decreased to 4. So now there are 4 schedules. Okay, 3 and 4. So reduce the number of schedules. Okay, so there will be one schedule for the animals which are of greater importance. Okay, and there will be another schedule which will be for lesser importance. Then there is one schedule which talks about the animals listed in CITES. Okay, so whatever the animals which are listed in the appendices of CITES will be listed in one schedule, and there will be one schedule for plants. So these are the 4 schedules. So the one schedule which was entirely for vermins were completely removed. Okay, now there is one schedule for greater importance, lesser importance for CITES and plants. So this is the first change which was done. Then this bill also proposes that the central government should appoint a management authority and a scientific authority. Scientific authority to study the wildlife status and recommend the management authority to take the decisions. There will be 2 separate authorities called as a management authority and scientific authority, which will be formed under the central government, and that will take care of the wildlife. Every person who is possessing a live specimen of wildlife should have a registration certificate. Anybody cannot have a wildlife, so if they don't have a registration certificate, so those registration certificates are issued by these authorities. Then there is one more change which was made for invasive alien species. The central government need to regulate or prohibit the import, trade, possession or proliferation or increase of invasive alien species. So the central government can authorize any officer for the capture or seize and also dispose the invasive species. So nowadays the invasive species, especially invasive alien species, is becoming a big menace to biodiversity. In order to control that, this provision on invasive alien species was included. Then the actions of CWW earlier were according to his will or the rules given by the central government. Whatever is the rule, it has to be implemented by the CWW. Now, along with that, whatever the decisions or whatever the actions which the chief wildlife warden takes, it has to be in accordance with the management plans of the sanctuary. Okay. So basically, whatever the management plans are there and whatever the changes which were proposed according to management plans, the action should be done according to that. So especially in those areas, because after 2006, there is an act which has been enacted called as Forest Rights Act. This is an act which talks about the scheduled tribes and other traditional forest dwellers. So it provides a right to them on various things. So it provides a right to have 4 hectares of land per family and cultivate there if at all certain conditions are fulfilled. It provides rights to these scheduled tribes and traditional forest dwellers for use of the minor forest products, for protection of plants and animals, for rehabilitation. So there are so many rights under this act. And if these rights given by the government will come under this, okay, so come under the protected areas, the management plan of the Gram Sabha will be incorporated into that, and the chief wildlife warden has to work in accordance with that. Okay. So that is one of the things. So these are areas which comes under the Forest Rights Act, given as a right to the tribals and traditional forest dwellers, were called as special areas, and those special areas should be dealt accordingly by chief wildlife warden. So conservation reserves, it empowers the central government to also notify a conservation reserves, which was earlier there only with the state government. Only state government were authorized to and state government were establishing the conservation reserves. Now even the central government can do that. Surrender of captive animals. One more provision which were included under this amendment, that any person can voluntarily surrender any captive animals or animal products to the CWW. So if any person come across a animal which are listed in these schedules and he is in possession of that particular animal, then he can surrender that animal to the chief wildlife warden. And if there is any product, even a product of a wildlife animal is under his capture, then it can subdue it. So for that submission of live animals or dead animals or even products will get no compensation, but if he voluntarily surrenders it, he will also be not punished. Okay. So this provision of no compensation is because if they started giving compensation, so because of the greed, they might start killing the animal wantedly and then surrender it to claim the compensation. So there is no compensation paid for this. So the penalties, the Act prescribes the imprisonment terms and fines under this Act. Anybody who infringes this Act will be imprisoned or fined, or both are done. So according to which. And in the amendment, the fines and the fines were increased. For general violation, earlier which was only 25,000, now it was made up to 1 lakh. And for specially protected animals, earlier it was 10,000, now it was made as 25,000. Okay, these are the two major amendments which were done. So for all the crimes which are committed under in the wildlife in India. So there are so many wildlife crimes like poaching, hunting, sale of the animal parts illegally, black marketing. So many things are there. All these are punished according to these terms. So this is what is the amendment of Wildlife Protection Act 2002. Okay, Wildlife Protection Act 1972's amendment in 2002. Now finally, before concluding, so the recommendations which we can give in this act, or the criticism which this amendment faced, or what could have been done in addition to whatever has been done, is that the SOX acts or the amendment doesn't talk about the human-wildlife conflict. So there is no provision, or there is no section which talks, or no amendment being done for the human-animal conflict. So that could have been included. So there is no provision for eco-sensitive zones. The Act doesn't talk about it. So this could have been updated or added in the amendment. So coastal regions, India is having a very vast coastal margins. So the wildlife crimes related to coastal aquatic animals or coastal regions, so there is no special provisions for that. So there is the wildlife crimes in coastal regions has not been addressed by this amendment. And some of the animals, say for example, the peacock feathers, if anybody possesses, or if anybody plucks, or anybody does it, it doesn't attract punishment under the Wildlife Protection Act, even though killing of that attracts a great punishment and fines, but their feathers, selling of these feathers and harvesting these feathers doesn't have any fine. So those small things need to be concluded. It has to work in coordination with the Customs Act 1972 or Animal Cruelty Act. So there could be some kind of coordination between various acts which also talks about animal cruelty. So those things could have been added to make the act more powerful. So that is about the recommendation which you can give for improving the act. If there is any amendment in future, so these things could be added. Now, there was a question in UPSC IFoS, Indian Forest Service Mains 2023 in Forestry Optional. The question said, discuss the salient features of Wildlife Protection Act 1972 and write its significance in dealing with the wildlife offences. So you can use all the information which we discussed and try to answer this question. This question was asked for 15 marks. So hope you have been equipped with enough knowledge to answer this question. So thank you so much. That is all for today. So see you with more exciting videos in the next class. Thank you.